Imagine this. You're driving home after a long day. Maybe you've got your family in the car. Maybe you're alone. Everything's normal. Then you see those flashing lights in your rearview mirror. Your heart skips a beat. You pull over. The officer walks up to your window. And then comes the question that changes everything. Do you have any weapons in the vehicle? Now, if you're a law-abiding gun owner with a valid concealed carry permit, your first instinct might be to be honest and cooperative. You might say, yes, I have a gun. You think you're doing the right thing. You think honesty will protect you. But here's the harsh truth. That simple statement, those 5 words, can be twisted, misinterpreted, and used against you in ways you never imagined. It can lead to criminal charges. It can cost you thousands of dollars in legal fees. It can even result in the suspension of your permit. And the worst part? You thought you were following the law. You thought you were being a responsible citizen. But in that moment, you gave prosecutors exactly what they needed to build a case against you. This isn't about being dishonest. This isn't about hiding anything. This is about understanding your constitutional rights and protecting yourself from a legal system that doesn't always work in your favor, even when you've done nothing wrong, even when you're completely legal, even when you're trying to cooperate. The words you choose in that moment can determine whether you walk away free or spend the next year fighting charges in court. So today, we're going to talk about the 5 most dangerous things you can say to police during a traffic stop when you're carrying a firearm. We're going to break down why these statements are so risky. We're going to look at real examples of how they've been used against legal gun owners. And most importantly, we're going to give you the exact words you should use instead to protect yourself, your rights, and your freedom. Let's start with the most common and most dangerous response. Yes, I have a gun. Sounds harmless, right? You're just answering the question. You're being honest. You're cooperating. But here's what actually happens in the legal system. When you say, yes, I have a gun, you're making what's called an admission against interest. You're confirming possession. But notice what you're not saying. You're not mentioning that you have a valid license. You're not explaining that you're a legal concealed carrier. You're not providing any context that protects you. All you've done is admit that there's a gun in your vehicle and that it's yours. Now, if everything goes perfectly, if the officer's reasonable, if there are no complications, maybe this doesn't become a problem. But what if there's a misunderstanding? What if your permit is expired by a few days and you didn't realize it? What if there's an administrative error in the system? What if the prosecutor decides to interpret your statement in the worst possible light? Suddenly, that simple admission becomes the foundation of a criminal case. Prosecutors can use it to establish knowing possession. They can use it to prove you had immediate control of the weapon. That they can use it to argue that you were aware of every detail of the situation. And here's the thing. Once you've made that statement, you can't take it back. It's on the record. It's in the officer's report. It can be used against you in court. So what should you say instead? If you're in a state that requires notification, here's the safer approach. Officer, I'm notifying you that I'm a licensed concealed carrier. Notice the difference. You're fulfilling your legal obligation to notify, but you're also immediately establishing that you're legal. You're framing yourself as a responsible, licensed individual. You're not just admitting possession. You're providing context that protects you. This simple change in wording can make all the difference in how the situation unfolds. Now let's talk about the second dangerous statement. It's in my glove box, or under my seat, or in the center console. Again, this seems helpful. The officer asked where the gun is, and you're telling them. You think this makes you look cooperative and transparent. But here's the legal problem. When you voluntarily disclose the specific location of your firearm, you're doing several things that can hurt you. First, you're establishing immediate control. You're confirming that the weapon is within your reach. This can be used to argue that you had ready access to it, which in some situations can escalate the legal risk. Second, you're potentially admitting to a storage violation. Different states and municipalities have different laws about how and where you can store a firearm in your vehicle. Maybe your glove box storage is perfectly legal. But what if there's a technicality you weren't aware of? What if the prosecutor argues that your storage method violated a local ordinance? By volunteering this information, you've just handed them evidence. Third, you're giving up your Fourth Amendment protections. When you tell the officer exactly where the gun is, you're consenting to that area being searched. You're waiving your right to privacy in that specific location. Now, the officer has a clear reason to open your glove box, search under your seat, or examine your console, and who knows what else they might find during that search. Maybe there's an old receipt that looks suspicious. Maybe there's a medication bottle. Maybe there's something completely innocent that gets misinterpreted. The point is, you've opened the door. So what's the safer approach? Don't volunteer location. Details. If you've already notified that you're a licensed carrier, that's enough. If the officer asks specifically about location, you have the right to say, I'd like to speak with my attorney before answering further questions. Is this going to make the situation more tense? Maybe, but it's also going to protect you from accidentally incriminating yourself. Remember, your job isn't to make the officer's job easier. Your job is to protect your legal rights. And sometimes those two things are in conflict. If you're finding this information valuable, do me a favor real quick. Hit that like button. It helps more responsible gun owners find this content. If you haven't subscribed yet, go ahead and subscribe now. We're building a community of informed, educated gun owners who know their rights and know how to protect themselves. Smash that subscribe button and join us. You won't regret it. And hey, share this with your friends who carry. They need to know this stuff too. Now let's move to the third dangerous statement. I have my permit. This one trips people up because it sounds like exactly what you should say. You're proving you're legal. You're showing you have nothing to hide. But here's where this can go terribly wrong. What if your permit is expired? Maybe it expired 2 weeks ago and you didn't realize it because you've been busy with work or family. Maybe the renewal notice got lost in the mail. Maybe you thought you had another month. It doesn't matter. If your permit is expired, even by 1 day, and you just told the officer, I have my permit, you've now made a false statement. That's not just an expired permit violation. That's potentially a separate charge for making a false statement to law enforcement. Or what if your permit was suspended and you don't know it yet? Maybe there was an administrative issue. Maybe a court case from years ago triggered an automatic review. Maybe there was a clerical error. These things happen more often than you'd think. And if you confidently tell an officer, I have my permit, when in fact your permit has been suspended, you've just made the situation exponentially worse. There's also the issue of permit verification. When you hand over your permit, the officer is going to run it through their system. And systems have errors. Databases have glitches. Information gets entered incorrectly. What if the system shows your permit is invalid even though it's actually current? Now you're in a situation where you've claimed to have a valid permit, but the officer's computer says otherwise. Good luck explaining that on the side of the road. So here's the safer approach. If you need to address your permit status, say this. Officer, I'm a licensed concealed carrier and I'd like to verify my permit status through my attorney. This protects you in multiple ways. You're still identifying yourself as someone who has gone through the legal process. But you're not making any absolute claims about your current status. You're building in protection in case there's an issue you're not aware of. And you're invoking your right to counsel, which is always a smart move. Let's talk about the fourth dangerous statement. It's for protection, or I carry it for self-defense. This seems reasonable, right? You're explaining why you have the gun. You're showing you have a legitimate purpose. But in the legal world, this statement can be devastating. Here's why. When you say it's for protection, you're establishing intent. You're telling the prosecutor exactly what was in your mind. And intent matters in criminal law. Let's say there's any question about whether you violated a gun-free zone law or a transportation regulation or any other firearms statute. The prosecutor can now argue that you deliberately chose to carry the weapon. You made a conscious decision. You had a specific purpose. This wasn't an accident or an oversight. You intended to have that gun with you for protection. That word, protection, just upgraded a potential administrative violation into a knowing and willful act. There's also the issue of how this statement can be twisted. A prosecutor might argue, well, if he needed protection, that means he anticipated danger. If he anticipated danger, maybe he was involved in something dangerous. Maybe he was expecting trouble. Maybe he wasn't just an innocent citizen going about his day. Now suddenly your innocent explanation has been reframed as evidence of suspicious activity. Is this fair? Absolutely not. Is this how it should work? No, but is this how it actually works in courtrooms across the country? Unfortunately, yes. Prosecutors are trained to take your words and use them against you in the most aggressive way possible. That's their job. So here's what you should say instead. Nothing. If an officer asks why you have a gun, you have the right to remain silent. You can simply say, Officer, I wish to speak with my attorney before answering any more questions. You don't owe anyone an explanation. You don't need to justify your Second Amendment rights. Your reasons for carrying are your business, not theirs. Almost done with the 5 dangerous statements. If you're still watching, thank you. This is important stuff that could literally save you from years of legal trouble. Before we get to the last one, do me another favor. Drop a comment below and let me know where you're watching from. What state are you in? What are the concealed carry laws like in your area? Let's build a conversation in the comments. And again, hit that subscribe button if you haven't yet. We're putting out content like this every week to help gun owners stay informed and stay protected. All right, the 5th and final dangerous statement, I wasn't going to use it. Or I forgot it was there. People say this when they're trying to minimize the situation. They think if they can convince the officer that the gun wasn't a threat, that they didn't have any bad intentions, everything will be fine. But this statement creates multiple legal problems. First, when you say, I wasn't going to use it, you're still admitting knowing possession. You're confirming that you were aware the gun was there. or you're establishing that it was yours and that you had control over it. That's an admission that can be used against you. Second, when you say, I forgot it was there, you're potentially admitting to negligent storage or transportation. If you forgot the gun was in your car, that might suggest you're not properly securing your firearms. It might suggest you're careless. It might suggest you're not following proper safety protocols. And all of that can be used to paint you as an irresponsible gun owner. Third, these statements can undermine potential legal defenses. Let's say you were pulled over near a school and there's a question about whether you violated a gun-free school zone law. If you say you forgot the gun was there, you've just destroyed any argument that you didn't have possession. You've admitted that the gun was yours and that it was in your vehicle. That makes it much harder for your attorney to argue that the gun wasn't actually in your knowing possession or control. So what's the right response? Same as before. Officer, I'm exercising my right to remain silent and I want to speak with my attorney. Don't explain, don't justify, don't try to talk your way out of it. Invoke your Fifth Amendment right to remain silent and your Sixth Amendment right to counsel. These are the most powerful tools you have and you should use them. Now let's bring this all together. Here's what you need to understand. Police encounters are not casual conversations. They're legal proceedings. Everything you say is being evaluated, recorded, and potentially used against you. And this is true even if you're completely innocent, even if you're totally legal, even if you've done nothing wrong. The legal system doesn't care about your intentions. It cares about what can be proven. And every word you say gives prosecutors more material to work with. Think about it this way. Has anything you've ever said to police during a traffic stop actually helped your case? Has volunteering information ever resulted in the officer saying, oh, well, in that case, you're free to go, sorry to bother you? Probably not. At best, your statements are ignored. At worst, they're used against you. So why take the risk? Here's your game plan for the next time you're pulled over while carrying. First, comply with your state's notification requirements, if they exist. Some states require you to immediately inform an officer that you're carrying. Know your state's law and follow it. But when you notify, use careful language. Say, officer, I'm notifying you that I'm a licensed concealed carrier. Not, yes, I have a gun. Not, I'm armed. Use language that frames you as legal and responsible. Second, if the officer asks follow-up questions about location, intent, permit status, or anything else, politely invoke your rights. You can say, officer, I've provided the notification required by law. I'm now exercising my right to remain silent, and I'd like to speak with my attorney. Is this going to be comfortable? No. Is the officer going to be happy about it? Probably not. But your job isn't to make friends. Your job is to protect yourself and your freedom. Third, document everything. If possible, keep your phone recording audio or video. Take note of the officer's name and badge number. Remember exactly what was said. If the situation escalates, you'll want a clear record of what happened. Fourth, get an attorney. Immediately. Not tomorrow, not next week. Immediately. Before you answer any more questions, before you go to the station, before you make any statements, a good attorney can often resolve these situations before they ever become criminal charges, but only if they're involved early. And finally, learn from this. Understand that carrying a firearm comes with legal responsibilities. It's not enough to just have a permit. You need to know your rights. You need to know what to say and what not to say. You need to be prepared for these encounters before they happen. Because once you're standing on the side of the road with an officer asking questions, it's too late to figure it out. Here's the bottom line. You have the right to remain silent. You have the right to an attorney. These aren't just phrases you hear on TV. There are constitutional protections that exist specifically to prevent innocent people from being convicted. Use them. Don't let anyone make you feel guilty for invoking your rights. Don't let anyone tell you that only criminals refuse to answer questions. That's nonsense. Smart, informed, law-abiding citizens use their rights all the time because they understand that the legal system is complicated and dangerous, even for innocent people. One final thought. This information could save you from criminal charges. It could save you from spending $8,000, $10,000, $12,000 on legal fees. It could save you from losing your permit, your job, or even your freedom. But only if you actually use it. So practice these phrases, memorize them, role-play the scenario with a friend. Be ready. Because the time to learn this isn't when you see those flashing lights. It's right now. If this video helped you, do 3 things for me. 1, smash that like button so more people can see this. 2, subscribe to the channel so you don't miss future content that could protect you. And 3, share this video with every gun owner you know. Text it to your family, post it in your gun groups, send it to your friends. This information is too important to keep to yourself. Let's make sure every legal gun owner knows their rights and knows how to protect themselves. Thanks for watching. Stay safe, stay legal, and stay informed. I'll see you in the next one.